Good afternoon. How are you? Well, I'm out. It's not raining now. It's overcast, so it probably will. Thomas Jefferson says the current temperature is 86 degrees. The humidity is 70. They say showers off and on all day, so we won't be surprised if we get wet. The wind is 1.6 miles an hour. Totally unaware that there is a wind. What I want to focus on, because it bothers me more than all the other stories that have their own elements of distaste, if you will. But the one that I'm interested in is the manipulation of the grand jury in the Epstein matter. That is, how does Trump pretend to be delivering information about Epstein while doing nothing of the sort? And there was a case back when I was a law clerk, and Trump, no doubt, also is familiar with the case. A very popular congressman got into a jam with the grand jury. And Trump may remember the tricky way that Mario Biaggi tried to use the grand jury to give him cover from an assertion of the Fifth Amendment before the federal grand jury when the U.S. attorney was Whitney North Seymour. And what he wanted to do was to ask to release the grand jury materials showing that he didn't take the Fifth Amendment, assuming the court would say, no, it's grand jury secret and confidential and it can't be released. And if the court said that, Biaggi could shrug his shoulders while he was running for mayor and say, well, you know, I tried. And I think that's what Trump is trying to do with his followers. He's trying to say, well, you know, I had the Attorney General ask, what more could I do? And here's the wrinkle that makes the Biaggi case so interesting. Because the Biaggi case, it was 1973. As I said, Biaggi was running for mayor, and it was alleged that he took the Fifth on October 29 and November 20th something, before the hoopla about him taking the Fifth. So he asked Mario, asked a three-judge panel to confirm he did not take the Fifth Amendment. Now, he assumed, and he had a very smart lawyer, he assumed that the judge would say, well, you know, it's confidential and I can't release it. And that's just the way it is, and you can't do anything about it. Now, the U.S. attorney also asked for the release of any testimony in which Mario Biaggi was taking the Fifth Amendment. And so the Third Circuit reviewed the case after the judge said, well, you know, I can't release that information. But the Third Circuit, a three-judge panel, ruled that the parties had waived the secrecy protection and released the testimony. Now, there was a critical dissent about this practice, that is, that you should not be beholden to the political machinations of the parties before you, in this case Whitney North Seymour and Mario Biaggi. But what happened was Nicholas Gage of the Times reported that Mario invoked the Fifth to 16 questions in the two grand juries. The second one more so because it involved the finances of himself and affected his daughter and other people. So the things that he hoped for didn't pan out. And the court denied his any other relief that he might have asked for. And so where do we have Trump now? We have Trump asking a court to release what it has that's pertinent to the Epstein matter. Now, if I were writing this and wanted to get anything out of the grand jury, assuming the most narrow cast for the grand jury material, I would invoke the fact that just as Biaggi had waived his right to secret protection, so does Trump do so by asking his Attorney General to release the information. Now, you and I know, Trump's not acting in good faith because he knows what the judge is likely to do. And so there's a little bit of a gamble here. But unlike Mario Biaggi, his backup is the Supreme Court. So he'll take it there, and they'll say, well, strict reading him. The statute in the grand jury says nobody gets to see that shit. But it strikes me that it becomes difficult to make that ruling if you push upon the court the notion that we want the release of any material involving Trump, because he's waived any of the secrecy protections himself. Now here's the rest of it, and this is where I'm at odds with all the commentators. No one actually gives this kind of analysis that I'm giving. And I believe they must know it. I think they're just avoiding talking about it because it's so obvious. And the second thing is, and I've heard variations of this, and this is correct, the stuff that goes before the grand jury is often hearsay. For example, an agent who has been involved in a case may come in and summarize 10 or 15 witnesses in hearsay, and that's sufficient for the grand jury. What good is that stuff? That's not what anybody wants to see. And then they'll try to delete other things. But most of the case, probably 96% of the case, is not before the grand jury in these summaries. It's in files that have never been before the grand jury. And that's the stuff that you demand there be no exceptions. Give us all of that. Don't mess around. Friday's a good time. See you at the courthouse. We'll bring trucks. We'll bring equipment to copy it. We'll bring whatever we need to do. That is the answer to this mess. The grand jury is another trick by lawyers that are not that smart, who don't remember, didn't consider, or decided in their arrogance to try it anyhow, is just say, oh, Judge, can't you release this stuff in the grand jury? And they're just, what the fuck is wrong with you? No, I'm not going to do that. That's what they're going to get. And then Trump is going to come out in the press conference, well, I'd stand, but my ankles are all blown up, and my skin is changing colors, and I've done all I can. And America should know that's all bullshit. And what the courts can do is surrender everything that he's conceded, and there may not be anything there, because what's before the grand jury are the two cases, or the various cases that went to trial. And there may not be any reference to Trump in those materials. All that stuff is sitting in files and on disks and in places by now, off campus, if you will, to be retrieved some other day in the future by Trump and his, for all I know, it's at Mar-a-Lago. So this is my advice to anybody who wants to talk about this. One, the grand jury effort is a dodge unless it's narrowed to what Trump has given waiver to release. Number two, the real stuff is in file cabinets and every place else and hasn't been before the grand jury and is not subject to a grand jury order, and all of that should be released, period. No ifs, ands, or buts or exceptions. So that's what I have to say for the day. I feel so much better because it's so frustrating to hear people talk about this like first-year law students. This is a con. Everybody should say it's a con. Everybody can see what the law is. And I think it's something about lawyers when I say, well, it'll probably work out this way. No, it will work out this way. Unless the judge has bigger cojones than the judge in the Mario Biaggi case. It's a shame about Biaggi. He was a very likable fellow. He was a hero. He had risked his life and been shot as a police officer upholding the law. And in the end, I think they convicted him of something like $3,200 gratuity. He spent at a camp or something, and I think he spent 28 months in jail. And because I was active in politics, I knew him and I knew his daughter. Although he's a Republican, I am a genetic Democrat, but he was open to all people. Well, at least in my narrow experience at that age. So that's what I got today, and I say have a wonderful soggy day amidst your cathedral of trees. All the best. Bye-bye.